Right, let's jump straight into this explainer. We're untangling the absolutely fascinating web of cross-border legal disputes. Have you ever stopped to wonder what exactly happens when a seemingly simple business deal or even a family matter crosses an international border and suddenly gets tangled up in multiple different legal systems? Well, today we are unpacking the incredibly complex concept of private international law. We're going to look at what it is, how it actually works in practice, and most importantly, and this is going to be our main focus today, we are going to dive heavily into exactly why a field of law that literally spans the entire globe is called private.
To really grasp the sheer scale of this problem, let's picture a hypothetical scenario. Imagine you're an Indian company making a massive deal with a French company. You sign all the paperwork over in Singapore, you route the cash through a London bank, but somewhere in the fine print, the contract demands that Indian courts resolve any fights.
So, when a dispute inevitably rears its head from this chaotic puzzle, how do we even begin to figure out whose rules apply? You've got an Indian buyer, a French seller, a contract born in Singapore, money moving through London, and a clause pointing right back to India. This dispute has what we call a foreign element, simply because it connects with more than one country or legal system. Without a clear set of rules to untangle this, we'd be looking at an absolute jurisdictional nightmare. Here is our roadmap to logically deconstruct this whole topic word by word. 1. The cross-border puzzle. 2. Why call it private? 3. The international element. 4. Jurisdiction, choice, and enforcement. 5. Public versus private law. And 6. Is it truly international?
Section 1. The cross-border puzzle. Defining the field. Let's start by defining exactly what framework we actually use to solve that Singapore-London-India scenario.
Here is the precise definition. Private international law is the branch of municipal or domestic law which determines the jurisdiction of courts, the applicable law, and the recognition and enforcement of foreign judgments in disputes containing a foreign element. Now, you're often going to hear this referred to in common law jurisdictions simply as conflict of laws. Think of it like the ultimate instruction manual for global disputes. It doesn't actually tell you who wins the breach of contract case. Instead, it tells you exactly which rulebook you have to read to find out who wins.
Section 2. Why call it private? Unpacking the name. Okay, this is the really interesting part and our central focus for today. If this law spans across the globe and deals with massive international disputes, why on earth do we stick the word private in front of it? Well, here is the core misconception we need to clear up right now. Private absolutely does not mean the issue is small, unimportant, or purely domestic. It exclusively identifies the non-state nature of the parties involved. In short, it's all about the who, not the scale of the dispute.
So who exactly are we talking about? Well, the disputes governed here are between private entities. That means everyday individuals like you and me, companies, massive multinational banks, traders, insurers, and even families and trusts. The unifying factor here is that these are private actors, not entire nations fighting over sovereign territory or diplomatic relations. So even if a dispute involves billions of dollars moving across 10 different borders, if the actors are private entities, it is squarely governed by private international law. It's the capacity of the parties that gives it the private label.
Section 3. The international element. Beyond borders.
Let's look at how a simple, everyday domestic dispute suddenly becomes an international scenario. It happens the moment a case connects with a foreign legal system. And this usually comes about through totally normal life events. It could just be based on the nationality or the domicile of a party. It could be the place where a contract was made, just like our Singapore example earlier, or where it was actually performed. It kicks in if property or assets are located abroad, if a civil wrong or tort occurs in another country, or even based on where a marriage took place. For instance, if a person domiciled in India dies while habitually resident in Canada, leaving behind property in England and assets in India, boom, you suddenly have questions involving Indian, Canadian, and English law. That right there is the international element at work.
Section 4. Jurisdiction, choice, and enforcement. The JCE framework.
So how do lawyers actually navigate this tangled web? Well, there is a highly structured process for this, and I absolutely love this part because it makes things so clear. Just remember the JCE mnemonic: jurisdiction, choice of law, enforcement. This is the practical architecture and pretty much the ultimate cheat code for understanding how every single case is processed. Step 1, jurisdiction. Basically, which court or country is competent to even hear the dispute? Should the case be heard in India, England, or France? Step 2, choice of law. Once a court actually takes the case, which legal system should it apply?
An Indian court might have the jurisdiction, but it might decide that French law is what governs the contract. And finally, step 3, enforcement. Will one country recognize and enforce the judgment of another? Because let's face it, a judgment won in Singapore is just a very expensive piece of paper if you can't enforce it against assets located over in India. JCE. It's really that simple, and it governs the entire field.
Section 5. Public versus private law. Drawing the line.
To truly cement why we call this private, we've got to directly contrast it with its much more famous sibling, public international law. And the contrast is stark. While public international law deals with massive treaties, wars, and sovereign states arguing in international tribunals, private international law is completely different. It's handled in domestic courts, and it deals with those everyday cross-border disputes between private persons and companies. Now, a quick caveat here. The distinction isn't always 100% absolute. A state-owned company might actually engage in a private commercial transaction, and that puts it right into the realm of private law. So again, the real distinction is based on the nature of the legal relationship. It reinforces that the private label is all about the capacity in which the parties are acting, not their size.
This contrast leads us directly into a really fascinating academic paradox. Is private international law actually international at all? Well, there are two main schools of thought here. First, the municipal law theory argues that it's purely domestic law. Why? Because there's no single universal code. Indian courts apply Indian conflict rules, English courts apply English conflict rules. They might literally reach totally different results on the exact same dispute. On the other side, you've got the internationalist theory, which argues it is international because it regulates relationships crossing national boundaries, avoids conflicting judgments, and facilitates global commerce. So what's the modern view? It's really a dual character. It's domestic in its source, but international in its source and operation.
Section 6. Is it truly international? Case law and conclusion.
To answer how this dual character plays out practically, let's look at how domestic courts wield these rules in real, high-stakes case law. Let's start with a landmark case from the Supreme Court of India, Satya v. Teja Singh. In this case, a husband tried to manipulate and misrepresent his domicile just to obtain a foreign divorce decree. But the court powerfully demonstrated that a foreign judgment must be tested under domestic law. They established an ironclad principle. Fraudulent creation of jurisdiction will not be accepted. Even though the decree was from a foreign court, the Indian court used its own private international law rules to say, "No way, this doesn't meet our standards for legitimate jurisdiction."
Similarly, look at the Y. Narasimha Rao case, another absolutely critical Supreme Court of India decision. This established that domestic courts will flatly refuse to recognize foreign matrimonial decrees if strict jurisdictional standards aren't met. If the foreign court lacked proper jurisdiction, if the ground of divorce wasn't recognized by the applicable law, if there was no voluntary submission, or if natural justice was violated, the domestic court is going to reject it. In essence, the domestic court acts as the ultimate gatekeeper of the international judgment.
And it is vital to know this isn't just an Indian practice. English courts do the exact same thing. In the famous case of Shibsey versus Westonholt, the English court established that a foreign judgment is never automatically binding just because it exists across the border. There has to be a recognized basis connecting the defendant to that foreign court. And in Adams versus Cape Industries plc, they looked closely at the limits of enforcing foreign judgments against corporations based on separate legal personality. So across the globe, courts apply their own domestic rules to manage these international private disputes. So we're going to leave you with this final thought. If domestic courts apply their own conflict rules, can they ever truly deliver unified international justice? As we've seen today, private international law is a brilliant, complex framework. It's called private because it empowers everyday individuals and companies, not just sovereign states, to navigate our globalized world. It uses the JCE framework of jurisdiction, choice of law, and enforcement to create some semblance of order out of cross-border chaos. It really has a uniquely dual character, regulating the globe while remaining fundamentally tethered to local courts. It's an imperfect, constantly evolving system, but it is for sure the vital machinery that keeps our interconnected world running smoothly. Thanks for joining us for this explainer, and keep questioning how the rules of the world actually work.